very much, and good afternoon. Today, two things happened in court. First was the court examination of Rojo Metonunu. So let me talk about that first. Rojo Metonunu was cross-examined by both counsel. And several things stood out. One, the issue of case or double for particular reasons. So for example, it has two sheets with different numbers on it and yet the same valid votes. And in court, we saw that apparently there was a third one lurking somewhere with a different timeline. We also saw that, for example, if you read his witness statement, Greater Accra was also an issue. Greater Accra, the numbers on the sheet did not add up. And interestingly, if you read the witness statement, you see that what was published, or the summary that was published on the website or by the EC, was different from what was actually given to the agents in the collation room. The other thing that came up was the fact that this was the National Collation Center where the returning officer, Jean Mensah, was supposed to be in control. We heard from their cross-examination that for a period of 3 hours, the agent of the petitioner was trying to get his problems or the issues that he had seen across to her without any success. We also saw the fact that they state that if you have signed the sheets, even if there are glaring problems on the sheets, nobody is going to do anything about it. This should give us all cause for concern. But even more importantly is the fact that Rojo Metonunu reiterated under cross-examination that it was the EC chair who asked him to convey message, information, whatever you describe it, to the petitioner. And if you read the witness statement, you realize that it was about a potential stakeholder meeting to discuss the concerns they had raised. And of course, as soon as they left, the EC and its chair, Jean Mensah, made arrangements to declare the results. Now, all these are issues of concern. Now, you probably would ask, how does this relate to the reliefs? If you have several collation seats for one region, which one was used for the declaration? I don't know. If you have sheets with different words in numbers in words and numbers in figures, which are different, which one was used for the declaration, or for collating, or for adding up the numbers? The only person who can tell us this is the EC chair, who's the returning officer.
Yes, she's not.
And that leads me to the second issue that rose today. They claim that they are not going to, or they stated, it's not even a claim, they stated clearly that they are not going to call any witnesses, even though they have submitted witness statements. Now, I don't know whether it's evading, running away, whatever, but they are avoiding or running away or evading the cross-examination of Mr. Chikata. We should remember that this is the EC, which has a constitutional duty to the people. They have an obligation to account to us for our stewardship. and they say they are not going to take the witness stand. Well, tomorrow we'll see how our lordships will rule on this. And the issue was raised whether it's a human rights issue. I don't know. This is the EC chair, a body created by the Constitution, which has an obligation to account to us. They are obliged, they have a duty to respond to our questions. They cannot, EC cannot hide under human rights to say they are not going to respond to us. So I respectfully disagree with her ladyship when she said it is a human rights issue. It is not a human rights issue. They are obliged to respond to us.
Thank you very much for this. I'd like to find out, you have closed your case today. You've closed your case today having called 3 witnesses, Asidun Ketia, Ojumeto Nunu, and Mr. Michael Wessa White. Having listened to them give evidence, would you say that your case is still tight? You intended to call some more. You advertised for 5. And when you asked the court for an application to look at documents within the EC, you were shut down. You now have 3. Would you say that you have a stronger case still?
Wouldn't I say that? I couldn't hear.
Your case is still strong?
Yes, I think we still do, because there is the issue of the declaration, which is why we are in court, where we stated clearly that even on the face of their own documents, nobody got 50 plus of the votes, of the valid votes. And in addition to that, as at now, the EC itself has come up with different figures. They are ever-changing figures. Which one is the valid votes which is supposed to be used for the declaration? They haven't answered that question.
Yes, Counsel, you have filed a petition making the point that no one got more than 50% of the vote cast. Each time your witnesses have been cross-examined, you've told us that you were satisfied with what has transpired. Should it not be in your interest that you've closed your case and the respondents you are seeking reliefs against are saying that, look, we don't intend to lead any evidence to show the contrary, that people had more than 50% of the vote cast? I mean, should that not be good news for you, actually?
Let me say it's of concern to us, and that is why we are going to oppose the application tomorrow.
Maybe closely linked to that, or following up on that, is a question of the relevance of that particular cross-examination to your case. The lead counsel for the Electoral Commission had made in his submission that indeed they are satisfied with what you have brought to court, and they think that the court can go ahead and make a determination without the benefit of the testimony and cross-examination of the returning officer. How crucial is this cross-examination to your case?
First of all, if we did not have a case, then they should not have filed any answer. Then they should not have submitted any witness statement to the court. Each of the parties have submitted witness statements. But my major concern is with the EC. That is accountable to all of us. The EC cannot say that it will not respond to questions raised by a petitioner, by a candidate.
One question that ran through the cross-examination is, with all the 3 witnesses you presented, is, do you have figures that shows that the second respondent did not get the figures, I mean the percentage that he had? That was one of the questions that ran through. I want to find out, you realize that, I mean, no figures have been provided by the witnesses and then the petitioner. Do you think with this, the court will grant your reliefs? Because the question that went through was, do you have figures that show that the second respondent did not get the percentage that he had?
First of all, please go back to our reliefs. Go back to the declaration. Go back to the different figures that have been churned out by the EC. I keep answering this question. I've already answered it. That by the declaration, by the different figures that have been churned out by the EC after the declaration, it is obvious and it is clear that no candidate got 50% or more of the votes. As to whether what was the question? I mean, with regard to our figures, that's irrelevant to the case. We've come with the EC's declaration itself.
I have a question. How compulsory must Jean Mensah's cross-examination be for your case to succeed? In other words, is the success or otherwise of your case hinged solely on her cross-examination? And if that fails based on what the bench will rule tomorrow, would you then determine that you have a lost case because you are unable to cross-examine them?
Of what you're saying.
If the bench rules tomorrow that she should not be cross-examined, would that throw your case out of the window automatically?
Well, first of all, we'll take it from there. We are going to argue whether or not the EC and the second respondent should take the witness box. Our view is that they have an answer there. They have submitted witness statements and they ought to be cross-examined on those matters stated there, because that is what they are using to challenge our case.
Yeah, but
so
my question is,
yes,
your argument has been put forth in the courtroom. Now the determination will be made by the bench tomorrow. Is the success or otherwise of your case hinged solely on this cross-examination? That's the question.
You note that when you go to court, your case is not just based on your pleadings and your evidence. There is also an answer, and in this case there's also a witness statement. And we think that it is important for us as petitioners to be able to cross-examine the EC in particular on the matters that she said.
Madam Winase, and the echo so our courts. Ye mamunyina ehu se sebe we die ya no eda semina so pass ye de petition at the bar courts 30th December yan wie kura na ode answer emuaye at the bar petition no so samuaye no eyensem na ode to answer no so afi ye say fa wenum asem evidence a support wo answer no fa betu court n'anima o say ndie mempe meko na se wo mpe na wo kɔ dia ndie de aba court no se court no enye den emfa mayen na court no nka say order for runoff. It's as simple as that. We enye dia ye ni electoral commission ye ba be twentwen ho asem ye ne de asem aba court say two candidates no obia bia ni ho a onya 50%. What the answer their backcourt say enye no kre yes be ya no edenti asema John Mahama ka no enye no kre o say ne de mempese menka se woni bibia edi hinta denti na wudwane sebe akankasem yes o dwane ekọ ahimfie kanea ene ntreso ayeden agise ye tutu wenum ayeden asem emne du si ebe tutu wenum asem a o se dabi we de misro dabi we de yesre adabraka ya mame embra witness boss no ejuma o di no Ghana bia 30 million Ghanaians onu kwa na etimidi se ejuma die no onu kwa na returning officer onu kwa na constitution e de se ejuma die na de ayeden e de ahye ne nsa mi amika se mintimi ndi se ejuma die no John Dramani Mahama enya de obetumi ayeden e di se ejuma die nipa baako pɛ sada no one na woyɛ declaration one na wogina hɔ simpie so se a na wɔkasaeɛ bɛkyerɛ yɛ akonta a woyɛ ya wo arrive at that calculation a wo sɛ ne deɛ memma we deɛ yɛsrɛ no yɛnkɔ akonodi yɛnkɔ no gopo yɛbɛyɛ no wɔ court da mu ha yɛsrɛ no sɛ yɛ naeɛ no ɔsomo yɛ a saa naeɛ no ɛtwam ɔne ɔmmra na nyame yɛ adom a ɛkyena yɛbɛba ne yɛde legal argument ɛde abɛtɛn ɛde abɛtu dwa sɛbe wonni hwee ɛhinta bɛka w'anum asɛm ɛ afaregya the first na wonim deɛ ɛyɛ wanwa ɛmmerɛ a nanado danko akufado ɛde petition ɛde ba ha wonim deɛ na no ɔka deɛ ɔka nyinaa ne sɛ presiding officer ansane polling agent asane bayɛmbɔ abatoɔ no ɛyɛ dɛn ɛngu ne ɛndeclare ɔno mampani afaregya wama ha yɛntutu n'anum asɛm wahu Philip Addison ano ɔde pink sheet ɛde kyerɛ no na yɛ maame deɛ dɛn kura no ahu nti a sɛbe dɛn kura no ɔde sie Ghanafoɔ ɔno na etua no ho sɛbio ɔno na etua no ho na owie a ɔnkɔ parliament ɛnkɔgye sika ɛnyɛ Ghana yɛ fotoɔ ne ɛde ma no nti sɛbe ɛkwan bɛn so na ɔgyina ne a ɔsɛ no deɛ I mean look ɛdwɛ bi yaba edwuma a ɔyɛ nim yɛn nyinaa esi ehu sɛ dwɛ ahamansoɔ ɛwɔ ne mmerɛ ɛyɛ court da mu ne ɛwɔ yɛn hwɛ akyira deɛ bɛsi afɔ deɛ rojo metinunu ɛbɛyɛ ne deɛ sɛbe yɛn nyinaa yɛ dɛn yɛhwɛ yɛ ɔmo yɛ ya sɛ mɛma wayɛ dɛn wa contradict no ne nyinaa yɛ dɛn anyɛ yie beebi a wogyina no hɔ no yɛ dɛn ogyina in fact ɛbɛba mu kura se ɛmra ɔmo lawyer aka se NDC ni bia mehu no na ɔmo a na eva mu si yɛ no ɛnɛ yɛ hu sɛ ɔkɔ ɔkura ɔmo ma ne ti wahu deɛ nyankopo ɛno no osuro sɛ ɔba witness box no mu a saa nneɛma yi nyinaa bɛba bɛde adi anaa sɛbe yɛn nyinaa yɛhu sɛ ɛyɛ Ghana ɛne yɛsom ɛnyɛ obi bia medam ase wotie ne yie